Good morning and welcome to this Eversheds Sutherland PROPcast. My name is Joe Geen. I am a professional support lawyer to the real estate practice group here at Eversheds Sutherland. Just some housekeeping before we start. This morning's session will last for half an hour and we do commit to sticking to time. I've put everyone's speaker on mute. That's just so we don't get any background noise, but that doesn't mean that I don't want to hear from you. So you can use the chat button to raise any questions at any time, and then depending on where we're at, I might answer those questions as they appear or save them to the end. And you can choose to send the question just to myself, or you can share it with everyone. That's obviously entirely up to you. We'll end the session on time, but I will stay on to answer any outstanding questions. So if your question hasn't been answered during the session, please stick around as I will get to it. And also just to note, as I mentioned earlier, this session will be recorded and will be made available via our website. Now, today's topic is titled Deal Breakers. As mentioned in the summary of this podcast, a lot of time and money are spent in finding suitable properties and then negotiating terms for their occupation. Normally, solicitors won't be involved until later on in the transaction, and that would be when a full review of the landlord's title is carried out. So the point of today's podcast is to highlight some of the major issues to keep an eye out for on title. So that's if you have sight of a copy of that title in the early stages of a deal. And it might be that by spotting any deal breakers sooner rather than later, it will help you avoid spending time and money working on a deal that ultimately might not be possible. Before we get into the detail, I'm going to outline some of the terminology which I'll be using in this PROPcast. Now, I'm sure that this will be familiar to many of you, so I'll just give a very quick refresh in case perhaps you haven't heard any of the terms before, or I'm using them in a way which you're not used to. So the first bit of terminology is title. In this PROPcast, we're focusing on registered title. So that is the title which has been registered at the land registry and, hopefully, shows that the landlord owns the bit of land or the buildings that we're interested in. In terms of what we actually look at when we're considering these questions, this will be the register and the title plan. The register is the written document which tells us the address or location of the property, what rights and covenants are registered against the land, if there are any charges, and, crucially, who owns it. This is where we'd be looking in order to answer most of the questions which are raised in this PROPcast. And for the eagle-eyed amongst you, you may notice that I'm using the register for the Eversheds Sutherland Cardiff office, which is where I'm currently sat. The title plan is the plan produced by the land registry which shows the property outlined in red. The title plan will often include other colours and bits of shading showing parts of the property are perhaps subject to rights, maybe those areas that are subject to leases, and land that has been sold off so it no longer forms part of that title. And we'll come to these a bit later on. As the focus of this PROPcast is from an occupier's perspective with a view of us taking a lease of the property and becoming the tenant, I will be calling the owner that we're dealing with the landlord. And because we're thinking about these issues from the perspective of a tenant who's considering taking a lease, when I say we or us, this is in terms of us being the potential tenant. So that's the terminology which I'll be using, and we can now move on to look at our first deal breaker. The first point we're going to look at is the registered proprietor. Now this is the person whose name appears on the register as owning the land. We'll be looking at exactly what they own in the next deal breaker, but for now we're going to focus on who they are. It might sound obvious, but it's surprisingly common for a party to think that they're dealing with a landlord, but once title has been looked at, to discover that a lease will be granted by a different party. And this can often be due to the property being held by a holding company, or a company registered overseas, or due to a name change. For example, Eversheds LLP, as mentioned on this title, has now become Eversheds Sutherland International LLP. Whilst the identity of the landlord may not be a particular concern, if the way in which the landlord holds the legal title is complex or does involve overseas companies, the legal work can be more costly and can take longer. For example, if a legal opinion letter is going to be required as the landlord is an overseas company, this can cause delay. Also, from 2021, there is to be a register showing the beneficial ownership of overseas companies which own land in the UK, and part of this regime will be to include a restriction on the register that can only be got around if the beneficial ownership register for that overseas company is kept up to date. So dealing with overseas entities can cause delay and is getting that little bit more difficult, which, if time is against you, might be a deciding factor. Well, also, where a lease involves onerous landlord covenants, such as the landlord delivering extensive services to the property or essential repairing obligations, the fact that the landlord entity is a holding company and not a parent company might be significant if this affects the overall covenant strength. So it's something worth checking, and if the result is anything unexpected, it's something to raise with the landlord's agent. Now, once we've worked out who is going to be the landlord, the next step is to think about what interest the landlord has in the land. And this is with a view to make sure that they have sufficient interest to grant us what we need. This will be revealed in the first paragraph of the register in the section with the title Property Register. If the title says that the landlord holds a freehold interest, we know that they have sufficient interest to be able to grant a lease of any duration. This will always be subject to anything else restricting what the landlord does. For example, if they have already granted a lease of the same area, or any restrictions imposed by a charge that the landlord has entered into with a lender. But broadly speaking, we know that they have a long enough interest. If the title shows that the landlord holds a leasehold interest, as it does here, it's going to be important to check that the landlord's lease is longer than the lease that we are asking for. This is because the landlord will not be able to grant us any greater interest than they have themselves. And when thinking about this, we must also not forget to include any renewals or any options to extend that we may want. And when you look at the register, as you can see from this example, you should be able to see when the landlord's lease term started and when it ends. If the landlord doesn't have a long enough lease to do a deal with us, it's worth asking how they propose to get around this. And if nothing is forthcoming or your query is met with just an awkward silence, it might be that this is not a deal that can be done. So, we've looked now at the duration of the landlord's interest, so we're going to turn to the physical extent of that interest. As I mentioned earlier, one of the key title documents is the title plan, which will show a red line around the land owned by the landlord, as is shown here on this example. When we're considering whether a deal can be done, we need to know that all of the areas that we are interested in sit within the landlord's ownership. And this will include any buildings, sheds, and open land which we need to be able to occupy. Quite simply, if the areas we want to take a lease of aren't within the red line, a conversation needs to be had pretty quickly. It might be that the landlord also holds an adjoining title, so they can patch together the titles and give us what we need, but it may not. In addition to the land that we're hoping to occupy, the landlord will have to prove that it is able to grant us the rights that will let us operate the property. These could be rights of way across a private access road that leads to the site, rights to use privately owned service media that run to the property across a third party's land, or rights of drainage. If the areas we need rights over are not within the red line of the landlord's title, we should be asking questions early on to get a feel for any potential issues. Often one parcel of land will have rights over adjoining land, which are discoverable by looking at what's noted on title. And this would normally be picked up as part of the full due diligence on the site carried out by the lawyers. So whilst the negotiation stage may not be the right time to drill down to the detail, it's a good time to raise the important questions with the other side, who will often be able to provide a degree of comfort around this. There is one intricacy which it's important to watch out for here, and that's any land which is edged green on the title plan. And we can see a small section of land which has been edged green here. And this occurs where the landlord has transferred part of its land to a third party, and rather than produce a new title plan showing what's left in the landlord's ownership, the land registry has just edged in green the bit which no longer belongs to the landlord. And just to mention that this isn't what happens if part of the land is leased, which is what we're going to turn to now. Leases for a term of more than 7 years should be registered, and leases of less than 7 years are often noted on title. So we're used to seeing a landlord's title which is littered with references to different leases. However, this becomes more important if any of those leases relate to the specific bit of land that we're interested in. If there is an ongoing lease, you'd normally see some evidence of the current tenant's occupation when you carried out a site visit, so seeing a corresponding note on the title will come as no surprise. However, if the land is bare land, or when you inspected it, it was empty, but there's a lease referred to on the register, then the situation can be less clear. So these notices can often be seen in the schedule of notices of leases at the bottom of the register, and that's what we have here. It's important to flag these to the landlord's agent and to ask if any leases are subsisting and might affect the deal that you're looking to do. There may be a valid explanation, such as where a previous tenant has surrendered its lease, but then the title has not been amended to show this. So it doesn't mean that we'll automatically be walking away from a deal, but it does prompt us to do a bit more digging. Now, following on from existing leases, we're going to consider other occupiers in a multi-let or perhaps neighbouring properties. Where the property is one of a number of units, such as you might find if it's situated in a shopping centre or an industrial park, there could be a broad range of occupiers spread across the site, and you'll normally want to know who your neighbours will be. This could be because you do not want to be based next door to a competitor, or you don't want to have your people in an office above a takeaway or right next to a heavy industrial user. And there are multiple ways of finding this information out. Often, this will be taken from what was observed on a site visit or perhaps confirmed by a landlord's agent. However, you can also find out some of this information by looking at the title. And this is particularly useful where the occupiers aren't obvious, such as with agricultural use or perhaps nondescript office buildings. And this can be in the schedule of notices of leases, which is what we saw on the previous slide, or in a note in the body of the register, as we see here. Apart from the question of who you might want as your neighbours, it can be important to check things such as whether any of the other occupiers have been granted exclusivity for that retail park or shopping centre in a way that might conflict with your intended use. Also, if a key part of your brief is to secure a minimum number of car parking spaces or bike storage racks, do your requirements fit with the current makeup of the site and what has already been granted to the existing tenants? It will take a more thorough review of the title documents and leases to find out this information, but it is certainly worth discussing these points as soon as possible when you do have those discussions with landlord's agents so that you can work out if more investigations are required or if it makes sense to cut your losses and look at other properties. And just a word of warning here, the register may not be entirely up to date, so perhaps one party is referred to as a tenant on the register, but they may have already assigned on their lease. So when we're looking at the register, we are getting a feel for perhaps who the other occupiers are and what uses they might have put the property for, but we always need to bear in mind that that information can change from time to time, so we will need to look at it in fuller detail. And we're now going to turn to a classic title issue, which is restrictive covenants. These are covenants which bind the land and prevent it from being used for certain purposes. A classic example is where land is subject to a restrictive covenant which prevents it being used for anything other than residential dwellings. This will clearly be an issue if we want to occupy and use the land for commercial purposes. Restrictive covenants are often obvious from the register, as you can see here. Now, sometimes the register will give the wording of the restrictive covenant, which helps you tell very quickly whether it's going to be an issue or not. If the register does not give you anything more than saying that there are restrictive covenants, as with our example here, the next step would be to ask the landlord's agent if they have any more information, but also to confirm who the recent occupiers of the land have been. Also, whether they've had any difficulties as a result of the restrictive covenants. This will at least give us an indication of whether this has been an issue in the past. So turning now to the final deal breaker which we're going to be considering. Now this isn't strictly something that comes up on title, but it is worth mentioning, and that's planning. This deal breaker, as I said, might not be something that you would discover on title, but it is very important. I've outlined some of the key questions which we should be asking ourselves in relation to planning on this slide. Is a planning consent in place? Is it possible to secure the necessary consent? If so, how long will it take? And of course, how much will it cost? It's essential to check if you're going to have all of the necessary planning consents to use the property. If the consents aren't in place, there will need to be a further discussion around who is responsible for obtaining them, how long might that process take, and do we want to enter into an agreement for lease to take the property, but perhaps only once planning has been granted. The first port of call will be to ask the landlord's agent for a copy of the consent allowing our proposed use of the property. If they don't have a copy, then we should ask for clarification on the current use of the property and what the legal basis is for it. As timing is normally critical, any uncertainty around planning may decide whether or not we need to start looking at alternative properties now. And whilst there may be a property which is sufficiently specialised or well located to justify entering into an agreement for lease, and then applying for a fresh planning permission, the additional cost, delay and hassle that would be incurred may put us off and lead us to look elsewhere. So that's time up, and that takes us through some of the key deal breakers at a high level which you might see on title. Now, I appreciate that lawyers will be involved and will look at all of this sort of thing in detail, but hopefully this gives you an indication of the sort of things that you might want to keep an eye out for and look into a bit further. Now, there are other points, of course, which could cause issues. These are things such as options and preemptions which might be registered against the title, but these would take up a whole PROPcast all of themselves, so we won't be looking at them now. Now, as I mentioned at the outset, I will be staying on the session to answer any outstanding questions. This session has been recorded, and a link to the recording will be put up on our website. So if you have any feedback on the session, please do feel free to get in touch. And likewise, if you'd like to make requests for topics for further sessions in the PROPcast series, or perhaps training for your teams in particular, please do feel free to drop me an email. My details are there. Now, if you are about to drop off the call, I hope that you found the session useful, and I'd just like to say thank you very much for attending.